So this, as probably most of you know, is the relevant industrial relations tribunal that deals with a lot of different matters, so unfair dismissals, bullying applications, enterprise agreements being approved, disputes under awards and enterprise agreements, and as Helen has discussed, the award modernisation process. Basically, some of the reforms around the Commission that may have some impact on business are just things like they're doing a review at the moment to look at efficiency and speeding up times of dealing with applications and getting in contact with relevant parties. So that can be relevant for business, particularly in where you've got a matter such as an unfair dismissal or a bullying application and you just want to get to the conciliation and have it dealt with and potentially over with. Also, they're looking at different ways, more electronic ways of interacting with what they're now calling clients. So businesses and employees, and how they can sort of make themselves a little bit more suitable to interacting generally with those parties, whether it's things like the award modernisation process and being able to get in touch with the Commission yourself without having to go through some sort of advocate, as well as other things such as we've seen with the bullying process, where they get on top of things very quickly, contact employers and really talk them through the process. So they're just trying to make things a lot more efficient and easier for businesses and employees. The next major change that's been proposed is a change to the structure of the Fair Work Commission. So currently it's quite a simple structure whereby you tend to come in a conciliation style process for things like unfair dismissals, adverse action claims, bullying applications. And it's a very informal process where you sit down with a conciliator or a commissioner and try and resolve the matter. If it doesn't resolve, it can move on to a hearing, which is much like hearings in other tribunals and courts, although a little bit more informal. And then there's an appeal body, which is the full bench. So the Coalition has proposed that there be a further appeal body on top of the current full bench system. And this is as a result of what they see as some issues to do with judgments not being consistent across the board within the Commission, as well as what they're calling the Commission being too top-heavy, so it's got a lot of very senior members and not a lot of junior members. Now, we could certainly have discussions about whether or not that's true and whether there are inconsistent judgments. However, it looks like there will be some sort of appeal process put in place, whether it's internal or external. And I guess the main thing that that's going to affect in terms of businesses is potentially some areas of the law that have been settled could sort of come into play again if an appeal body looks at them and makes different decisions, particularly if the entire appeal body is appointed by the Coalition. They may tend to be more employer-friendly members than the current members, so there could be some changes to issues such as things we've seen about social media or bullying, etc. The other major thing that it should change is, I guess, the process and the timing. So you could be spending longer in the Commission, which is not great, particularly given their ideas around making things more efficient and cost less and be more client-friendly. So we'll have to wait and see whether that gets through the Parliament, but it is proposed, and it's something that in the past the Coalition has created different bodies when they've come into power around court systems, so it's likely that they'll push forward with that. Now, the next major topic that I wanted to talk about is the Fair Work Act, and it's something that seems to be continuously changed and amended, as we've had it for quite a few years now. A number of amendments have come in with minor changes or more major changes, and I think there's been some criticism around this area of law, which is constantly changing given its sort of ideological nature, and every time we get a new government they want to bring in their take on employment law and industrial relations. So it's due to be looked at by the Productivity Commission, but not until late next year or early the year afterwards, and that's something that will more fundamentally review the entire Act, its regulations, how it operates, and there could be some major suggestions out of that the coalition will take forward to the next election. But in terms of what the current changes are that are important for businesses, the first one is around annual leave loading. So this is an area which in a lot of awards, employees are entitled to annual leave loading on their holidays, so 17.5% usually. And there's been some contention around whether if an employee is terminated, they still get paid that 17.5%. So recently the Fair Work Ombudsman, who is not part of the tribunal, they're a separate body that provides information for employees and employers and also can prosecute employers, put forward its view that the 17.5% does have to be paid on termination. However, that's not a binding view, it's just their view generally. So the government has decided to clear that up by saying in the new proposed legislation that it's not payable on termination unless an award, an enterprise agreement or a contract says it's payable. So it's just a small area of the law that potentially could save some costs for employers on terminating employees, and certainly could change the idea around getting people to take their holidays all the time to make sure that they're not only having a break but that's all paid for. So that's the first area. The second area, which is a bit more contentious, is the idea of a small business immunity. And this sounds quite fancy, but when you break it down, it's not actually that much of an immunity. So it's a proposal that if a small business has gone to the Fair Work Ombudsman, so they have a hotline and you can email them, etc., and ask them about advice on a particular industrial relations matter, and they receive the wrong advice, they should have immunity from prosecution by the Fair Work Ombudsman. So it's not a broad-reaching, if you come forward to the Ombudsman, then you can go away and do whatever you like and you can't be prosecuted. And it doesn't appear to be an immunity from, for example, back pay if you paid someone incorrectly. It's just that the Fair Work Ombudsman can't bring you forward to the Commission and seek pecuniary penalties against you. But it is something that a lot of small businesses could be in favour of, particularly if they're dealing with the Fair Work Ombudsman on award interpretation and so on. And I mean, I don't know if any of you have dealt with the Fair Work Ombudsman before, but they don't tend to give very yes or no advice. They sort of give, well, it could be this or it could be that, or they could be covered by this award. So I don't know that you're going to get much immunity if they're just giving you several possibilities about something. So it's probably not as fantastic as it first sounds.